People thought those bulldozers were coming to destroy a neighborhood, but the truth was far more unbelievable. The first thing I heard that morning was the deep, rhythmic growl of diesel engines rolling across the valley before the sun had fully climbed above the eastern ridge. Their sound echoed through 1,500 acres of open pasture that my family had worked for generations, shaking the windows of the old ranch house just enough to wake me before my alarm ever had the chance. I stepped onto the weathered wooden porch with a mug of black coffee warming my hands, breathing in the familiar scent of damp earth, fresh-cut hay, and cedar carried by a cool spring breeze. In the distance, a convoy of bright yellow bulldozers and heavy equipment slowly made its way toward the southern entrance of my property, each machine moving with deliberate precision instead of urgency. From the county road, the scene looked exactly like the beginning of a massive demolition project, and within minutes pickup trucks began pulling onto the shoulder as curious neighbors climbed out to watch. Some raised their phones to record. Others simply stood there whispering among themselves. They all believed the same thing. They believed I had finally lost my temper. They believed I had somehow found a legal excuse to flatten an entire subdivision. Then I heard another familiar sound drifting across the pasture. A luxury sport utility vehicle stopped beside the entrance gate, and Patricia Collins stepped out wearing an immaculate white blouse beneath a tailored navy blazer, sunglasses perfectly in place despite the early morning light. Even from nearly 100 yards away, I could recognize the confident smile on her face. She folded her arms and watched the bulldozers approach with the satisfaction of someone expecting the next few minutes to end in handcuffs for the man she had spent the last year trying to discredit. Behind her, several homeowners gathered near the stone entrance monument of the subdivision, pointing toward the equipment while children asked confused questions their parents could not answer. The smell of diesel mixed with fresh grass as the heavy machines rolled closer, their steel tracks pressing neat patterns into the gravel access road leading toward the newest section of homes. Nobody noticed that each bulldozer carried official county identification numbers on its doors. Nobody noticed the sheriff's vehicles parked quietly behind the convoy instead of racing ahead with flashing lights. Fear has a way of making people see only what they expect to see. I rested my hand against the rough cedar fence post beside the ranch gate, feeling grooves my grandfather had carved into the wood decades earlier while measuring property lines that everyone else had long forgotten. The brass survey marker sitting only a few feet away caught the first rays of sunlight, shining almost as brightly as it had when he showed it to me as a little boy. He used to tell me that land could be argued over by lawyers, politicians, and developers, but the truth always waited patiently beneath the grass. I never fully understood what he meant until that morning. Patricia certainly did not understand. She waved confidently toward the approaching convoy as though she believed those machines had arrived because of her. What she did not know was that every bulldozer, every deputy, every county official, and every document inside the lead truck had come for exactly one reason. The law had finally finished reading the paperwork, and 1,500 acres of land were about to remember who had owned them all along. Nathan Carter, 41 years old, third-generation ranch owner. My family never measured wealth by the size of a bank account because everything that truly mattered stretched across rolling hills, open pasture, and quiet creek beds that had carried our name for longer than anyone in the county courthouse could remember. 1,500 acres looked endless to most people, but to me every fence corner, every limestone ridge, and every oak tree held a memory. I could still point to the exact spot where my grandfather taught me how to read an old survey marker buried beneath wild grass. He used to kneel beside the weathered brass disc, brush away the dirt with his work gloves, and tell me that property lines were not just measurements on paper. They were promises passed from one generation to the next. My father believed the same thing. Every spring we repaired fences before the cattle were moved into fresh pasture. Every autumn we walked the boundary together carrying old county maps folded inside plastic sleeves to make sure nothing had changed after heavy storms. He always smiled when we reached the stone entrance near the southern ridge because the original marker placed there decades earlier never moved, no matter how many seasons passed. After graduating from Texas Agricultural and Mechanical University with a degree in land management, I had opportunities to build a career in the city. Friends accepted jobs in Dallas, Austin, and Houston, chasing larger salaries and taller office buildings. I came home instead. Some people thought I lacked ambition. The truth was exactly the opposite. My ambition was to protect something that could never be replaced. The ranch house still carried the scent of cedar beams my grandfather cut himself. The old cabin overlooking the creek still had his initials carved beneath the front window. Even the heavy iron gate at the main entrance squealed with the exact same sound it had made throughout my childhood. Those little details reminded me every morning that I was only the newest caretaker of a much older story. The county records reflected that history just as clearly. Every deed, every probate filing, every tax payment, and every license survey pointed to the same ownership stretching back across generations. I kept certified copies inside a fireproof cabinet because my father insisted important documents deserved the same protection as valuable equipment. At the time, I considered that habit overly cautious. Looking back now, it became one of the smartest lessons he ever taught me. About 6 years before everything changed, new development signs appeared beyond the southern boundary. Construction crews cleared brush, utility trucks arrived, and glossy advertisements promised luxury homes with scenic ranch views. I welcomed the new neighbors because good fences and respectful conversations had always defined country living. I waved at workers passing the gate, answered questions when surveyors asked for directions, and even allowed temporary access across one service road after heavy rain washed out part of the county route. I believed simple courtesy created good neighbors. I had no idea that somewhere between those small acts of kindness and the first completed homes, someone had started treating my family's patience as if it were permission. Standing on the porch that morning while diesel engines echoed across the valley, I realized those quiet decisions made years earlier had become the first pieces of a much larger story, one that had already begun rewriting the history of land my family had never stopped owning. The first time I met Patricia Collins, she arrived carrying a polished leather portfolio instead of a welcome basket. She introduced herself as the president of the newly formed Homeowners Association with the confidence of someone who believed every signature she placed on paper automatically became the law. She was 56 years old, impeccably dressed, and always seemed prepared for a neighborhood meeting even when everyone else was wearing work boots and dusty jeans. Her smile was practiced, her words were polite, and every compliment somehow ended with a suggestion about what other people should do. At first I thought she simply took pride in keeping the new subdivision organized. I had no reason to believe otherwise. She admired the view across my ranch, complimented the old stone entrance my grandfather built by hand, and even asked questions about the history of the property. I answered every one of them because I had always believed sharing local history was part of being a good neighbor. Looking back, I realized she had not been asking out of curiosity. She had been gathering information. As construction continued, Patricia became more visible than the builders themselves. Every groundbreaking ceremony featured her standing beside developers, smiling for photographs, welcoming new homeowners, and describing exciting plans for future expansion. Large signs appeared along the county road advertising premium homes with sweeping ranch views and private countryside living. The brochures displayed green hills, peaceful ponds, and open meadows that looked remarkably familiar. More than once I found myself studying those glossy advertisements because the landscape printed behind the smiling families looked exactly like sections of my own land. At first I assumed the marketing department had simply used nearby scenery to promote the neighborhood. Then one afternoon a young couple stopped at my front gate carrying a folded subdivision map. They politely asked whether the hiking trail shown on their property brochure crossed the creek beyond my western pasture. I looked down at the map, and my stomach tightened. The trail they pointed to did not exist inside the subdivision. According to the colorful illustration, it crossed nearly half a mile of my family's ranch before looping around the old cabin overlooking the valley. I explained that the entire area belonged to private property and had never been included in any residential development. The couple looked genuinely surprised. They apologized, thanked me, and drove away, but that conversation lingered in my mind for days. Soon after that, I began noticing wooden stakes with bright orange ribbon appearing suspiciously close to my southern boundary. Survey crews worked without ever speaking to me. Construction equipment occasionally parked near fence lines that had stood unchanged for decades. Every time I questioned what was happening, Patricia answered with the same calm confidence. She insisted the developers had completed all necessary legal reviews and assured me there was nothing to worry about. Her certainty was so complete that many people accepted it without asking a single question. New homeowners trusted her because she represented the Homeowners Association. Contractors trusted her because she attended planning meetings. Even local suppliers assumed everything had already been verified because construction continued without interruption. I remained polite, but something no longer felt right. My grandfather used to tell me that land could not speak, so owners had to pay attention whenever small details started whispering. Standing beside my ranch fence one quiet evening, watching another row of framed houses rise against the sunset, I realized those whispers were becoming impossible to ignore. The next few weeks felt like watching someone slowly redraw the edges of my family's history without ever asking permission. Every morning another construction truck rolled through the subdivision entrance, carrying stacks of lumber, roofing materials, or concrete forms, while survey flags multiplied along the southern edge of my ranch like bright orange weeds after a spring rain. I decided it was time to stop relying on assumptions, so I hired an independent licensed surveyor whose family had worked throughout the county for more than 30 years. We spent 2 full days walking fence lines beneath the Texas sun, stopping at every original brass survey marker my grandfather had shown me as a child. The surveyor brushed away dirt, compared coordinates with certified county records, and quietly nodded each time another marker matched the original plats filed decades earlier. Nothing had moved. The boundaries remained exactly where they had always been. What had changed was everything happening inside them. When the final measurements were complete, he unfolded a large map across the hood of my pickup truck. Fresh construction roads, utility easements, and dozens of newly divided residential lots extended well beyond the legal subdivision boundary and crossed directly onto my property. I remember staring at the map while the smell of warm paper, dust, and fresh-cut cedar drifted through the afternoon air. It was not a small mistake. Entire sections of my family's ranch had been incorporated into development plans that should never have existed. I refused to believe something this significant could have happened without someone noticing, so I gathered copies of the survey, photographs of the property markers, and certified county plats before requesting a meeting with Patricia Collins. She welcomed me into the Homeowners Association office with the same polished smile she always wore, offering coffee before I had even opened my folder. I placed the survey on the conference table and calmly explained what the licensed measurements had revealed. Patricia glanced at the documents for only a few seconds before sliding them back across the table. She insisted their development team had already reviewed every property line with attorneys and engineers years earlier. She suggested my surveyor must have relied on outdated information and assured me there was absolutely nothing to worry about. I asked whether she could show me the recorded plats supporting the subdivision boundary she described. Instead of answering directly, she changed the conversation to future neighborhood growth, increasing property values, and the importance of cooperation between longtime landowners and new residents. I left that meeting with more questions than answers. During the following month, I sent certified letters to the Homeowners Association, the developer, and the county planning office, attaching copies of every survey, photograph, and county record I possessed. I requested written clarification before additional construction continued. Some offices acknowledged receiving my documents. Others remained silent. Meanwhile, new foundations appeared, utility lines expanded farther into the landscape, and freshly framed homes rose where cattle had grazed only a year earlier. Every evening I stood beside the old stone entrance my grandfather built, listening to the distant sound of nail guns and diesel engines echo across the valley. Those sounds no longer represented progress. They sounded like a countdown, and with every passing day I became more certain that someone had built an entire future on paperwork that could not possibly withstand the truth. By the time autumn arrived, the subdivision had grown so quickly that people driving along the county highway assumed it had always been there. Freshly painted homes lined newly paved streets, decorative streetlights illuminated sidewalks every evening, and landscaped entrance signs welcomed new families who had no idea that part of the neighborhood stood on land that had never legally changed ownership. The hardest part was knowing those homeowners were not my enemies. Most had invested their savings believing every document placed before them had already been verified. I could not blame families who trusted professionals. My concern had always been with the people responsible for making those promises in the first place. I hired a title attorney with decades of experience handling complex property disputes across Texas. Instead of encouraging dramatic action, he asked for one thing: every document my family had ever kept. For nearly 2 full days we sat inside the old ranch house surrounded by faded county maps, probate records, tax receipts, warranty deeds, survey reports, handwritten notebooks from my grandfather, and yellowed filing envelopes that still smelled faintly of old paper and cedar shelves. Each document became another piece of a puzzle stretching back generations. The attorney compared every recorded transfer, every subdivision filing, and every county plat against the official title history. Late one afternoon, he removed his glasses, leaned back in his chair, and quietly said something that completely changed the direction of the case. According to the official chain of title, ownership of my family's land had never legally transferred to the developer or the Homeowners Association. Somewhere during the subdivision approval process, a series of inaccurate legal descriptions had been copied from secondary planning documents instead of the recorded property deeds. Those mistakes continued through later paperwork until people simply accepted them as fact. The county planning illustrations reflected one set of boundaries while the recorded title documents reflected another. The difference covered hundreds of acres. My attorney immediately requested certified copies from the county recorder, the tax assessor, and the probate archives to confirm every detail before taking another step. Weeks passed while additional records arrived. Every new document strengthened the same conclusion. The original deed remained valid. The probate transfers remained valid. The annual tax records remained consistent. Even the oldest survey filed by my grandfather matched the newest licensed survey I had commissioned only months earlier. Nothing in the legal chain showed that my family had ever sold the land. Armed with those records, my attorney filed a formal action asking the court to determine ownership before any additional development continued. Construction slowed but did not completely stop. Patricia Collins continued assuring residents that everything would be resolved in the developer's favor and that the lawsuit was merely a misunderstanding created by outdated paperwork. I never answered those public statements because there was nothing left to argue. Every conversation now belonged inside court filings rather than neighborhood meetings. Some evenings I stood beside the old brass survey marker near the southern ridge as the setting sun cast long shadows across both the ranch and the subdivision. The cool breeze carried the mixed scents of fresh concrete, cut lumber, and wild grass, reminding me how closely the two worlds now stood together. Looking across the valley, I realized the outcome would affect far more than property lines. It would determine whether recorded ownership still meant something when tested against years of assumptions, and for the first time since this entire ordeal began, I believed the truth finally had the evidence it needed to speak for itself. The first court hearing lasted less than an hour, yet it changed everything I thought I knew about patience. My attorney never raised his voice. He never accused anyone of stealing my family's land or demanded dramatic speeches from the other side. Instead, he carried 3 neatly organized binders into the courtroom, each filled with certified county records arranged in chronological order. Every document had been authenticated. Every survey had been prepared by licensed professionals. Every deed traced the ownership of the ranch through generations without a single lawful transfer removing those 1,500 acres from my family's name. Across the room, Patricia Collins sat beside attorneys representing the Homeowners Association and the developer. They appeared confident at first, placing oversized subdivision maps on the table and describing years of successful construction, completed home sales, and neighborhood growth. Listening to them, someone unfamiliar with the history might have believed the case had already been decided. Then the judge asked one simple question that immediately shifted the atmosphere inside the courtroom. He requested the recorded instrument showing when my family's property had legally transferred to the developer. The room became noticeably quieter. Several attorneys began sorting through folders, while the sound of turning paper echoed across the courtroom. One document after another appeared, but none contained a recorded deed signed by my family. They produced planning approvals, engineering exhibits, subdivision layouts, and development proposals. Yet none of those documents established ownership. My attorney calmly stood, walked to the presentation screen, and displayed the official chain of title obtained directly from the county recorder's office. Every recorded transfer appeared in chronological order. Every probate filing matched tax records. Every license survey aligned with the original brass markers still standing across my ranch. There was no missing page. There was no hidden transaction. There was simply no lawful transfer. The judge spent several minutes comparing the official title history with the subdivision exhibits before requesting additional certified copies from the county archives to eliminate any remaining uncertainty. Rather than rushing toward a conclusion, the court scheduled further review and instructed all parties to preserve existing evidence while ownership questions were fully examined. Construction activity on the disputed sections slowed significantly as additional legal filings followed. During the weeks that came afterward, survey specialists, title experts, and county officials independently reviewed decades of records. Each new report reached the same conclusion through different methods. The legal descriptions used during portions of the subdivision planning did not match the recorded deeds governing ownership of the land itself. Standing outside the courthouse after one of those hearings, I breathed in the crisp autumn air mixed with the scent of rain drifting across the parking lot. I realized I no longer felt angry. For months I had watched assumptions grow into neighborhoods, but inside that courtroom assumptions carried very little weight. Certified records did. Original deeds did. Accurate surveys did. Patricia passed by with her legal team without saying a word. The confidence that had once defined every conversation had become careful silence. My attorney looked at me and quietly reminded me that property disputes were rarely won by emotion. They were won by documentation that could withstand every question the law was willing to ask. As I drove back toward the ranch that evening, the fading sunlight reflected off the old brass survey markers near the southern ridge, and for the first time since this ordeal began, I could finally see the path leading back to the land my family had never truly lost. Several months after the first hearing, the courtroom felt completely different. The uncertainty that had surrounded the early proceedings had gradually disappeared beneath stacks of certified reports prepared by independent professionals who had no personal interest in the outcome. Licensed surveyors testified about boundary markers that had remained untouched for decades. Title experts walked through the complete chain of ownership one document at a time. County archivists produced original record books preserved long before the subdivision had ever been imagined. Every witness approached the same conclusion from a different direction, yet every path led back to the same place. My family had never legally transferred ownership of those 1,500 acres. The judge reviewed each exhibit with remarkable patience, asking detailed questions about recording procedures, legal descriptions, subdivision approvals, and title requirements. My attorney rarely interrupted because the documents were answering the questions more clearly than any speech ever could. Across the courtroom, Patricia Collins no longer projected the confidence that had defined our earliest meetings. She listened quietly while attorneys for the developer acknowledged that portions of the project had relied upon legal descriptions carried forward from planning documents rather than verified recorded deeds. Nobody argued that the homes themselves had been built carelessly. The issue was far more fundamental. The land beneath part of the development had never legally belonged to the parties who sold it. That distinction changed everything. The final written ruling arrived several weeks later. I remember sitting inside the old ranch house while rain tapped softly against the windows as my attorney placed the signed order on the dining room table my grandfather had built by hand. The court confirmed my family's ownership of the disputed acreage, declared the affected property transfers invalid where they depended upon land outside the lawful title chain, and directed the appropriate county agencies to oversee the legal process necessary to restore compliance with the ruling. Any structures remaining on the affected parcels would be addressed through lawful enforcement procedures under county supervision. There were no dramatic celebrations inside the room. My attorney simply smiled, closed the file, and shook my hand. Outside, the rain had stopped, leaving the air smelling of wet cedar, fresh soil, and cool autumn grass. During the following weeks, county officials met with engineers, title companies, utility providers, and property owners to organize the next steps. Every decision followed written procedures instead of emotional reactions. Residents received explanations, legal notices, and opportunities to understand exactly how the errors had occurred. Many were shocked to discover that they had been victims of inaccurate transactions rather than intentional participants in a dispute. Several families stopped by the ranch to ask respectful questions after reviewing the public records themselves. I welcomed every conversation because none of them had created the problem. They had simply trusted paperwork that should have been verified before construction ever began. One evening I walked to the old brass survey marker near the southern ridge as the setting sun painted long shadows across both the ranch and the neighboring subdivision. The marker looked exactly as it had when my grandfather first showed it to me decades earlier. It had never needed to move because the truth it represented had never changed. The law had finally caught up with the land, and for the first time since the story began, I knew that everything waiting beyond the horizon would no longer be decided by assumptions. It would be decided by the same quiet records my family had protected for generations. The convoy I had watched from my porch weeks earlier finally reached the disputed section of land, but everything looked very different now that I understood what every vehicle represented. County inspectors arrived first, followed by engineers, utility supervisors, title representatives, and sheriff deputies assigned only to maintain a peaceful work environment while the court order was carried out. Every person carried clipboards, rolled maps, or inspection binders instead of rushing through the neighborhood. The same yellow bulldozers that had frightened so many people remained parked with their engines off while officials walked property lines one final time, comparing survey markers, legal descriptions, and engineering plans against the court's written decision. The morning air carried the familiar scent of damp soil mixed with diesel fuel, fresh lumber, and cedar trees swaying gently beyond the old ranch fence. Standing near the original stone entrance my grandfather had built decades earlier, I watched professionals measure every boundary with remarkable care. Nothing happened until every document matched every marker in the field. That patience mattered because the court had not ordered punishment. It had ordered compliance with the law. Several homeowners stood quietly beside county representatives as the process was explained once again. Some homes located entirely outside the disputed acreage remained untouched because they had never occupied my family's land. Others had been built on parcels the court determined could not legally remain as recorded. Engineers carefully marked those locations while utility crews disconnected services according to established procedures before any construction equipment moved forward. There were no raised voices. There was no celebration. Only the steady rhythm of professionals completing responsibilities that should never have become necessary in the first place. Patricia Collins arrived shortly after sunrise wearing the same polished style she had carried throughout this entire ordeal, but the confidence that once defined every conversation had been replaced by quiet reflection. She stood beside county officials reviewing the final paperwork without interrupting anyone. I noticed her looking toward the old brass survey marker near the southern ridge, the same marker she had dismissed years earlier as an outdated piece of metal. Now every engineer, surveyor, and attorney treated it with complete respect because it represented the legal boundary that had existed all along. One by one, construction crews began carrying out the court-approved restoration plan. Structures affected by the ruling were removed only where required under county supervision and engineering guidance, while reusable materials were carefully separated for lawful handling. Dust drifted slowly across the open pasture as heavy equipment moved with deliberate precision instead of speed. I rested my hand against the weathered cedar fence post my grandfather had installed many years before, feeling the same rough grain beneath my fingertips that I had known since childhood. Around me, the sounds of machinery blended with birds calling from the oak trees and the steady breeze rolling across the valley. It struck me that the land itself seemed remarkably unchanged despite everything people had argued about for so long. By late afternoon, the large subdivision entrance sign no longer overlooked acreage that had been mistakenly included in development plans. Temporary barriers marked the restored property boundary, and county officials completed their final inspection reports before leaving the site. As the last bulldozer slowly rolled away beneath the warm Texas sunset, I realized those machines had never represented revenge. They represented the moment when written records, patient persistence, and lawful authority finally restored the truth that had been waiting beneath the grass from the very beginning. Nearly 6 months after the county completed the restoration work, the ranch felt like it had finally learned how to breathe again. Spring returned quietly, covering the rolling hills with fresh green grass, while wildflowers appeared beside the same limestone trails my grandfather and I had walked together years ago. Every morning I opened the heavy iron ranch gate and heard the familiar creak that had greeted 3 generations of my family. The sound had never changed. Neither had the old brass survey marker standing proudly beside the entrance, catching the first light of sunrise exactly as it always had. Only now people noticed it. County officials had updated every public record, corrected every property description, and completed the final title revisions required by the court. New boundary maps reflected the original legal ownership, and every future transaction involving the surrounding area would begin with those corrected records instead of the assumptions that had caused so much confusion. The families who had been affected gradually found new paths forward through agreements, relocations, and lawful solutions supervised by the county. Many of them stopped by the ranch one last time before moving on. They shook my hand, thanked me for treating them with respect throughout the process, and admitted they had never imagined a mistake buried inside decades of paperwork could change so many lives. I wished every one of them well because they had trusted documents they believed were accurate. They had never intended to become part of someone else's legal battle. Patricia Collins resigned from the Homeowners Association not long after the final proceedings concluded. Months later, I happened to see her at the county records office while renewing agricultural permits for the ranch. She offered a quiet greeting, and for the first time since we had met, our conversation contained no arguments, no assumptions, and no speeches about authority. She simply acknowledged that some decisions should have been verified before anyone asked families to invest their futures. I appreciated the honesty because accountability often begins with a single truthful sentence. That afternoon, I drove back across the ranch, stopping beside the old cabin overlooking the valley. The cedar board still carried my grandfather's initials beneath the front window, and the breeze carried the familiar scent of fresh grass, weathered timber, and warm earth rising beneath the Texas sun. I unfolded the same county map he had shown me when I was a boy and placed it beside the updated survey prepared after the court ruling. Every property line matched perfectly. The old map had never been wrong. It had simply waited for people to read it carefully. As the sun slipped lower across the western hills, cattle wandered peacefully through open pasture where construction equipment had once stood. Meadowlarks called from the fence posts, and the valley settled into the quiet rhythm I remembered from childhood. Looking across all 1,500 acres, I finally understood what my grandfather had meant when he said land remembers the people who protect it with patience instead of pride. Ownership is not proven by the loudest voice or the biggest promise. It is proven by truth that survives every question. The bulldozers were never the ending of this story. They were only the final page in a much longer record written by careful hands, preserved through generations, and ultimately confirmed by the law. Standing there beneath an endless Texas sky, I realized my family had not won because someone else lost. We won because the truth had finally been given the chance to speak, and when it did, the land simply came home.